Hi, everyone. It's Grant Abbott speaking, and we're looking for this quick short session and case study, which is changing discretionary trust positions. Mick, I know you obviously you've got lots and lots of clients through I Love SMSF and through your accounting positions. I mean, how often are there family breakups or issues where you need to change beneficiaries or trustees or appointors, etc.? And obviously it's a pain in the butt, but needs to be done.
Yeah, I mean, it is quite a regular occasion. Surprisingly enough, I've done more than I've done ever during COVID. There's been a number of, and exactly for the reason you said, relationship and marriage breakdowns. I'm not sure if it was due to being locked up for a continuing amount of time, but I'm finishing one at the moment for that's just got a family binding family agreement on it. So.
Yeah, which seems to be the case. And we have a look at it. I mean, for me, it's a really hard bill because you'll see on our site that we've got, I'm going to take you through the case study, but we've got a change in trustee for SMSF. And then what happened is someone said, look, we want to, remove beneficiaries and put in new beneficiaries. So gradually over time, we started building up all these separate documents, and smart aleck me, because I always like a challenge, thought, well, why couldn't we just put everything into one agreement and then make it easy so we could be in a position of ensuring that really covers all our scenarios. And I want to go through and show you how we've done it. But if we have a look at it from a discretionary trust point of view, and okay, sorry, Christopher. So, can you hear me now? Is that a lot better? So, hopefully. Okay, so thank you for that. So, what we've done is you can make a lot of these changes to these positions, and I'll do that, and I'll show you. But essentially, there's a commissioner's guideline which we looked at yesterday, which is Tax Determination 2012/21, which talks about no resettlement. And I think this is important for us to sort of go into this one right at the moment. I'll come back to this, but it's one that I get all the time. And I must admit, Tony and I have probably been hoodwinked in the past by listening to too many lawyers, 2012/21. And effectively, we've listened to a lot of these lawyers and, in essence, talking about this idea of resettlement. And this came out in 2012, obviously, which is pretty easy. Does CGT event E1 or E2, which talks about, obviously, disposal of assets in sections 104-55, 104-60, if the ITAA happen, if the terms of a trust are changed pursuant to a valid exercise of power. And you'll find that most trusts enable changes to the trust, which is important. So if we have a look here, and this is really important. So in these circumstances, CGT1 happens, neither event happens unless the change causes the existing trust to terminate and a new trust to arise for trust law purposes, or the effect of the change or court-approved variation is such as to lead to a particular asset being subject to a separate charter of rights and obligations, such as to give rise to the conclusion the asset has been settled on terms of a different trust. Now, that may happen, for example, when there's a subtrust. Now, I have seen, if you have a look at Div 7A, the impact of potentially companies and trusts, that if we're obviously going back to the trust, we can create a subtrust there. If you haven't had a look at Div 7A and subtrust, just flick it onto the ATO website and have a really good look. But that creation of that subtrust is a brand new trust that is being flowing out of the existing trust. So let's just go down and have a look at a couple of examples: addition of new entries and exclusion of entities. So the Acorn Trust is a family discretionary trust that was settled to benefit the members of the Squirrel family. Under the terms of the trustee, a private company of which Mr. and Mrs. Squirrel are directors, has the power at its absolute discretion to appoint income to any one or more of the general beneficiaries. The general beneficiary is defined on the terms of the trustee to be Mr. Squirrel, his wife, their children, their grandchildren, and a proprietary limited profit company through which the family runs a business of growing flowers to supply local forests. So that's, that's pretty typical. Having decided to get out of the flowering industry, the Squirrel family disposed their interest in oak to an unrelated third party. The trust deed for the Acorn Trust provides for a procedure for the trust to be amended by trustee resolution, which is pretty typical for most trusts, recorded in writing. Pursuant to this procedure, the trustee resolves in writing to amend the deed to specifically remove oak proprietary by name from the class of general beneficiaries. The trustee further resolves to add to the class of general beneficiaries respective spouses, trusts and companies in which the family has a majority controlling interest, and a philanthropic charity unrelated to the Squirrel family. So there's quite a lot of change to that trust. When you have a look at it, because effectively we've got rid of one set of beneficiaries and put in quite a different set. Now here we've got the making of these resolutions being a valid exercise of power does not give rise to the happening of a CGT event. Expansion of the power to invest, addition of definition of income, power to stream, and extension of vesting date. Now, any bright person would see that this is 2012, which is post Bamford in 2011, which is one of the reasons they put that in. So you can actually change the vesting date. So let's go in here. The Lime Trust is a discretionary trust settled in 1980 to benefit the members of the Linda family. The trustee contains no definition of income, nor does the deed contain a provision permitting the trustee to stream income. The deed contains a clause specifying the date on which the trust is divested, 30 September 2020. Pursuant to an unfettered power of amendment in the deed, the trustee resolves in writing to amend the deed to insert two clauses. One is the first defining the income, so that's the Bamford side. The second, authorising the trustee separately identify and label various sources of income, again, Bamford. The trustee further resolves to amend the deed by changing the vesting date to 2550. Again, the making of the resolutions does not give rise to resettlement. Extension of the vesting date, just got to make sure it doesn't infringe the rule of perpetuities. We are looking at changes of jurisdiction, how that would be. Now, this is this Div 7A issue and settling of a trust asset on a new trust. So this is a really important one. The Hedgerow Trust is a discretionary trust, the class of objects which consists of a large number of entities associated with the Buttercup family. Under its terms, the trust has a wide range of powers, including the power to declare the particular assets of the trust to be held exclusively for one or more of the trust objects at the exclusion of the other objects of the trust, which is essentially the beneficiaries. In exercise of this power, the trustee declares one of the several assets forming part of the corpus of the trust, asset one, was henceforth held exclusively in trust for one of the objects, Mr. Badger, subject to the trustee's other powers, such as power of sale. 1 month later, the trustee makes a second declaration, similar effect in favour of Mr. Badger in respect to one of the remaining assets of the Hedgerow Trust, asset number 2. While respective declarations do not terminate the Hedgerow Trust, so that's important, the effect of the declarations is that assets 1 and 2 are no longer held on that trust. Rather, the trust obligations attaching to these assets have changed in a manner consistent with the conclusion the assets are convinced to be held on the terms of a separate trust for Mr. Badger. In fact, I would probably argue there's potentially 2 trusts there for the old badge man. So if we have a look at that, I mean, all of our thinking in the past about not being able to upgrade discretionary trust deeds, for example, upgrading a discretionary trust deed to a leading member discretionary trust, which obviously has a lot more control, asset protection, and also bloodline protection. We've obviously in the past thought about resettlement, but here the Commission is saying there's no such issue. What I would do though is I'm not going to have time, but I would certainly reference this, and you can get this from the second session from yesterday. I'll put that in as a reference, but have a really good read of this around resettlements. And the Commissioner goes through, and particularly commercial nominees, I know a few of the parties are involved in that, looks at the High Court case around resettlements, and then all of this, I mean, really, Tony and I couldn't even do I think both of us probably could, but, you know, it gives some great legislative interpretation and case interpretation around what is and what is not a resettlement. In fact, I used to know Justice Edmonds, who was at the Tax Institute when I was there. So when we have a look at that, if someone says to you, look, you can't, what you're doing is going to involve resettlement, just give them the tax determination. And the Commissioner's done all the argument, and it's up to them to actually say, well, it does or it doesn't. Anyway, let's get back to the case study at hand. Having a look at all of this, I'll get on, and I must admit, Tony, are you there at all? Or?
I am.
Yeah, so I must admit, when we both had a look through that, from our thinking for many, many, many years in trust law position, we're always concerned, particularly from a tax perspective, about capital gains tax in resettlement. Even I remember being told many years ago when I first started out in tax law that you couldn't add beneficiaries, or you couldn't change trustees or appointors, or otherwise it would end up as being a resettlement. But it clearly looks it's not the case at the moment.
Yeah, no, it's not. But you just got to go through that tax determination and
have a really good look at it.
Yeah, have a really good look at it, basically. Yeah.
Okay, let's see how Tony and I work this out. So we've got the Smith Discretionary Trust, established on the 1st of November 2001, with John and Sally Smith as trustees, appointors, and beneficiaries. And this probably just goes to, in fact, we're seeing quite a bit of this, and Mike was alluding to it just a little while ago, that John and Sally have been recently divorced, and the family law orders require Sally to retire from all positions in the Smith Discretionary Trust. So when we have a look at that, John's got a new de facto. Janice Brown would like to include her as a beneficiary and trustee, but not an appointer of the trust. They would also like to change the name of the trust to the New Life and Love Family Trust. So when you're looking at doing that, honestly, that would, if you took that down to the local solicitor and said, this is what you're doing, what would you expect the fees to be, Mick and Tony, out of that one?
Instructions, conference time, drafting, all that
crap.
Be about 1,500, $2,000.
Yeah, I would say, look, I've got $1,000 there, $1,000 plus, but I think you're probably up around about 2.5. So that's why this was really
advice.
Yeah, depends who you're using as well. I've seen upwards of 5,000.
Oh, really?
Ridiculous.
Or something.
Ridiculous.
I know. No, look, you'd be so surprised at what some lawyers charge. Okay, so we go to our document categories, and you'll see here, obviously, there's change there for trusts. This is for discretionary trusts, but also applies for leading member of family protection trusts. So I just click on there, start the document. I'm going to take a little while to go through it. I want you to understand each and every one, how we're going to do this. So I'm going to start this and that flicks us straight into the system, which seems to be working very well today. For those who haven't done the fix on Chrome, you find the link there. You just got to go through a couple of little things to fix up Chrome. Unfortunately, Edge looks as though it's got a bit of a dodgy thing. It's when they change cookies. So this is the Smith a change in positions, just so I can then go and find a little bit later on. I've got the Abbott-Family logo there. Now we go through the general. So we need to know the name of the trust. So we go to Smith leading member family trust. So what's the deed of the change of position? Let's say we've got the client coming in next Monday. So I'm going to use the 9th. When was the original one? So it's the 1st of November 2001. So has the trust been varied in the past post the date of establishment? The good thing that compared to SMSFs, you generally don't find it that often. So I'm going to go no. But if you went yes, then obviously you put the variation dates there. So go and have a look at your last deed, and that will tell you whether things have been varied or not. Okay, so do we want to change the name of the trust? Yes, of course. So the new name of the trust is, what is it? Oh God, I can't remember. I came up with such a dorky name. Oh, New Life and Love Family Trust. So I just thought that'd be like a nice New Life and Love Family Trust. So the date of the change of the trust name is the 19th. Is there an appointor? Yes. So that'll pop up. You can see there, as soon as I click that button, and that's why this is so intuitive. As soon as I click yes, another party comes up. So I'm going to go no, but then I'm going to go yes. So then I go down to the trustee. The trustee are two individuals. So we've got John Smith. So put his current address. So we've got 5 Smith Street, Sydney, New South Wales, 2000. Add another trustee. So at this point in time, Sally is looking at retiring, but she's still the trustee. So she needs to be put in there. So she's at 100 Sydney Road, Fairlight. So she picked up the family home, Fairlight, New South Wales, 2095. So they're the trustees. So don't forget to include both of them as trustees. So Phil, what happens when you don't have a copy of the trustee or know if there's been any amendments? Has happened for a few new clients in the past. What I would suggest anyway to clean things up, Phil, is what you can do is there's an expensive route. You can go to the Supreme Court and swear by affidavit as to what the terms and conditions are. That's probably about a $25,000 to $30,000 exercise. Or you can put in place what you call a lost deed, a deed of lost deed. And if you want to do that, we can do that at Abbott-Family. And so if you want to do that, it's not on the system because it's just a little bit tricky. But if you want to do that, just contact Tony. So I think you've got his details, Tanamillis at abbotmolly.com, and we can do that deed for you. So I'd strongly suggest you do that because at least it gets you on an even keel and do that. The other one that I would do, and look, well done, Phil, because you're throwing yourself, I'd have to say a hat tip to Phil in terms of throwing yourself into all of these sessions as many of you do. Because the more you look at these, the more value you're actually going to get out of not only subscription, but out of being a better professional. The other one I would do is when you're going through the change, obviously we're going to do a change here, but it's not a bad idea to actually do a change in the trust deed as well. So go through this process, change everything, or alternatively, change the deed, for example, to a leading member trust deed, go through that process of variation, etc. So there's no resettlement, and then go through this process after that. Or probably you're better off doing this and then making a change. So you've got a brand new deed and brand new positions. And that, yeah, I'd basically do that. So the current appointor is obviously John Smith. But remember, unfortunately, Street, Sydney, New South Wales, 2000. Unfortunately, remember, we also had Sally Smith as the appointor. So, and she was at, I think, 100 Sydney Road. And we are going through this stage to make this a lot easier where we can store names and addresses. So I've just got our development team looking at this. So we're just going to make it so much easier. 2095. So we put in all the current details of the fund as we've seen. So we get our deed out or lost deed. Phil, go to Abbott-Family and we can sort that out for you. Okay, now we get down to the changing party, which is pretty important. So the changing party is going to be the individual. So what we've got there is Sally Smith. So she's the first one. And you'll see this is where the brilliance comes in. So Sydney Road. The sooner we get this, the better anyway. It's not as if it's too painful, but I do this day in, day out. So 2095. Okay, so we've got Sally and we've got court orders. So she is an appointor, she is a trustee, and she is a beneficiary, and she is retiring. So we've done that. So effectively, we've booted Sally out of the process. Now we have to add another, and what we've got here is an individual, and her name is Janice Brown. So this is the de facto. She's living with John. And then we've got, let's see, Sydney, New South Wales, 2000. Okay, so what's happening with her? Well, she is becoming a beneficiary and also a trustee. And I'd probably, remember, You can actually go through the place here. If you wanted to change the trustee, I could upgrade it to a corporate trustee, but I'm just going to make it easy here. So she's now the new person there. Now, so we've done all that stuff, which is great. And that seems pretty simple, but it's not that simple. There's a lot there. Now, this is the one that caused me consternation. So you ready for this? So let's just go through. We've got the trustee. So we're happy with John and Sally. So they're the existing ones. She's about to be booted. Current appointor, John and Sally again. Changing party, we got Sally. She's going to be retiring from appointor, trustee and beneficiary. And then we've got Janice coming on. She's the new one, and it's trustee and beneficiary. And again, you can change the leading member, as I said before. Okay, so the clause or consent. So you can see what clause or rule an existing trustee provides for the change in the appointor. So I have to go into the deed there. And if there's an issue when you're going through this, put it up on support and we can have a look at it if you want. So let's say rule or clause 4.5 allows the appointer to be changed, but who is the person who allows it to change? It's the appointor. So the appointor in the deed, the existing deed, has a capacity to do that. So I put 4.5. Now we're changing the trustee. So what we've got there is 3.2 is a relevant clause that allows the trustee to change the trustee. Changing beneficiary. So we've got there 6.1. And that's, again, the trustee can make a change there. So you can see all that. Changing the name, which is usually coming around a variation of the deed, which is going to be the same if you want to upgrade the fund, which you should be, or I'd suggest you'd want to do after this, to a leading member discretionary trust. So let's say that's 9.2. And then again, that's a trustee issue. So you can see how it's easy to do all the drop-down boxes. In fact, I don't know why most legal firms don't use our system, but anyway, at some point in time they will. So what we do is that's all crunching and bringing all its stuff together, and then we'll go and have a look at what the output looks like. Now remember, of course, this goes into your vault, so I won't go into that, but you can, if you've got any changes you want to make, and go back. So we've got a deed of variation for the discretionary trust. So we've got the Smith leading member family trust. We've got the Abbott-Family sign off there. So the deed of variation for discretionary trust, we're changing the appointor, the trustee, beneficiary name change. So again, all of the things that we're doing is highlighted there. So the actual logic behind this automation is, well, I think it's absolutely amazing. Again, hats off to our developers on that one. So we've got the trustee, John and Sally, the appointor, John and also Sally. Now, the changing appointor, Sally, who's going to be the retiring one. Changing trustee is Janice, who's the new trustee, and Sally, who's the retiring trustee. Changing beneficiary, Janice, new beneficiary, Sally, new beneficiary. So we've given them all a name in the system. So the trustee was established by deed 1st of November 2001. The trustee has been notified there are changes in various trust positions as noted below. So all the rest of tales about all of this sort of stuff is to be taken up as operative provisions of the deed. So the retiring appointor, which is Sally, hereby resigns as appointor pursuant to blah. The new trustee is appointed as trustee of the trust pursuant to this. The retiring trustee hereby resigns as trustee pursuant to that. The new beneficiary is appointed as beneficiary of the trust pursuant to this. The retiring beneficiary hereby blah, blah, blah. The trust name is to change from the Smith Leading Family Trust to New Life and Love Family Trust from 19th of October. All parties by execution of this deed access to be bound. The change in trust position affected by this deed does not result in resettlement. So then we come down to the signing. So we've got the trustee, we've got the old Johnny Smith there, and also Sally Smith. Now the appointor, we've got John Smith, and we've also got Sally Smith there. Okay, so now we've got the new trustee and beneficiary, which is Janice Brown. So she can sign on behalf of both of those positions because she's the trustee and beneficiary. And then we've got the retiring appointor, trustee and beneficiary, which is Sally Smith. So she's signing off for the three. So in that one small document, we've got like hundreds of things going on, and it's pretty sophisticated. So what do you think about that one, gentlemen? I think I've dazzled them.
Fantastic.
I know. When you have a look at that, I mean, that's a lot of work to get through, but, just from a simple thing. So what I would suggest is that, as you go down the track, that don't use our change in trust, don't use this, use this system for any changes where you can actually in there. But this will be up on the system again. We'll have a look at that. So that to me is I haven't launched that yet, but to me that's probably the most exciting thing that I've done, because it really shows the power of automation and how it becomes really simple. But again, to make something really simple, and remember this, some of you probably know. So Brett Edmonds, does the name need to be changed with the ATO? Absolutely. So I remember seeing Edward de Bono, and he wrote a thing on something called Simple, and he wrote a great book on simplicity, which is probably pretty important now with COVID. But essentially he said, look, in order to make something simple, you need to know it really well indeed. You can see there all that stuff that's been able to do. We've sat down and crunched through all the possible permutations. Now, is that going to be the final version of it? No way, because again, remember, we use the principle of Kaizen. You guys are going to go in and say, oh gosh, we might have you, for example, Brett, saying, oh, Grant, can you put in here, I've got a principle, or I've got this, or I've got that. Can you add or detract from that? But the good thing about it is we've got that commissioner's determination that says all of that stuff there we can do effectively, and there won't be a change in thing, and it won't be a resettlement or a capital gains tax issue. In fact, going through all of that, one of the elements that I just thought is a potential change in vesting date. So what I might even do is put that in there as well. If the trust holds any properties, will it trigger stamp duty if the trustee is changed? What do you think, Tony? I would say no.
No,
not at all.
That's what originally was in commercial nominees. Remember, they tried to change the trustee, and they assessed them, and they took it to the High Court and said basically, well, you can't do that. You know?
Well, there you go. Thank you very much for that, Tony. So exactly. So the Commissioner's whole rationale around resettlement in the High Court case was commercial nominees, where they tried to trigger a capital gains tax and stamps in terms of a change of trustee.
That was insane. I mean, just because you're changing the trustee doesn't mean there's a resettlement. I mean, that's crazy.
They're desperate. Phil, what happens when the husband and ex-wife do not get on and we have to get the ex-wife to sign the documents? So in some instances, you may be able to go in and have a quorum and do that. So with our position, that's the benefit of having a leading member trust as opposed to a discretionary trust, because you'll find a leading member trust, the leading member can boot the ex-spouse out, or the spouse out, or anyone out as trustee, boot them out as beneficiary, do all of that sort of stuff as well, and veto anything. So depending on what your deed says, Phil, it may be difficult if she doesn't want to sign. So perhaps it might be worthwhile to upgrade the deed if possible. Have a look through the terms and conditions of that, whether it's easy to upgrade to leading member deed, and then take it from there. But usually when you have cases like this, the family lawyer is obviously pretty on top of it, because they'll want to review everything. And of course they'll do that because they can charge fees for it. But again, look, any of these sort of issues, contact Tony or myself at Abbott-Family. Well, you've also got Michael as well. So I'm sure Michael is quite happy. He's been through a lot, but Michael comes in from an accountant's perspective. So what sort of questions are you happy to sort of discuss with people? I know you're a bit of a company's guru there, Michael.
Yeah, I mean, I'm happy to discuss any questions on a range of matters. So certainly been across all of them. That question Phil was mentioning too, I guess it depends as well if there's been a binding financial family agreement, financial agreement. So the one I'm doing at the moment, there is, and so their wife's being removed, so she has to sign. So I mean, there's obviously family lawyers on both sides. So
yeah, which is again probably having a look at this. We've all got cases, but it's absolutely crucial, depending, because at the end of the day, would I be right in saying, Michael, you only end up with one client out of the whole deal, and the client is the one who was with you in the first place. So it's why getting that leading member trust or that upgrade is absolutely crucial for ongoing protection. And remember, it's protection of the bloodline of your client, not the whole family. And you'll see that when you even upgrade to the leading member trust, for those of you on the session yesterday, you can exclude the spouse as a beneficiary, because obviously you have to include her because she's never going to be your bloodline. So have a really good look at that. As I said before, we'll have a look next week at the new strategy center. I'm going to put a lot more resources up there so that, you know, we can use it as a go-to. And Tony and also Michael, if you want to send any resources you find quite useful. I know you've got a lot of liquidation stuff, Michael, and what we'll do is we can start to build that strategy center out to a really good strategy center, a really good resource library as well for everyone to go in and have a jump at. As I said, Tony and I will be doing that deep dive on 101, but it's not, we've got a Will's introduction session, which is already up on the, in the strategy center. This one will actually be quite a hardcore deep dive going in there. And really for any of you who are going into this area, want to go in that asset, succession asset protection and estate planning, make sure you use that. The other one is when you do go through your documents, just make sure that if you see any issues or you see wording on an interview that should be cleared up or you want more expansion, let us know, because again, just these little small changes make huge differences. And the investment strategy, I can see we've made huge changes. And again, we're still going through on a day-by-day basis. Now, the moat and castle, which I showed yesterday, which is the be-all and end-all of client comprehensive, changing of deeds, changing of this. I'll actually put this document up into the moat and the castle. Effectively, that I'm going to do a pop-up presentation. I've just got to get it to the stage where I want, and then once we do that, we'll then go and release it to the world. So just watch out for that because it'll be pop-up. Anyway, thanks, guys. You've gone.
Just one more thing, just coming back to that, to the change of trustee stuff. With so we know that there's no stamp, triggering of the capital gains or stamps on that one there, right? But the only thing you've got to be aware of when you're doing a change of trustee and there's a mortgage on, on a trust somewhere, what you got to do is make sure, you got to make sure that you've got to notify your bank, basically.
Yeah, exactly.
But Michael can help you out with that.
Yeah, so I think that's a really good point. And registering a mortgage if there's a change in name, etc. Yeah,
so that's gonna. So you got to take all that into account. But Michael Jeffries can help you out with that stuff.
Super Mick. So that's what we call Super Mick. Superman. Okay, guys, thanks a lot for coming, and thank you everyone for coming. These will pop up onto the Strategy Centre later on today. It's Grant Abbott, Tony, and Mick signing off.
Thank you.